Welcome back to the Customs GST Advisory channel of the customsgst.com. We are getting a lot of views, but the subscription buttons is not being pressed by all viewer. Please press the subscribe button and share this video. A state government sells lottery tickets to a distributor. The obvious answer seems simple. The distributor pays GST under reverse charge. But here is the question that can completely change the tax outcome. Where is the place of supply? What happens if the ticket is delivered within the organizing state? What if it is delivered outside the state? And what if the distributor tells the government to ship the tickets directly to a third party? One lottery transaction can therefore raise three very different place of supply questions. First, understand the legal architecture. The Lotteries Regulation Act 1998 permits a state government to organize a lottery subject to statutory conditions, and Section 4 recognizes sale of lottery tickets either by the state government itself or through distributors or selling agents. GST then operates on this statutory commercial structure. Therefore, when we analyze the GST liability, the first question is not merely who sold the ticket. We must also ask, who is the legally recognized lottery distributor or selling agent? Before we discuss RCM, place of supply, or CGST versus IGST, there is a more fundamental question. Why is lottery taxable under GST at all? The answer lies in the treatment of actionable claims under the CGST Act. Section 7, read with Schedule 3, specifically keeps actionable claims outside the scope of goods and services, but with a crucial exception: lottery, betting, and gambling. In other words, the exclusion is not for every actionable claim. Lottery is expressly carved out of that exclusion. Therefore, lottery does not disappear from the GST net merely because it is an actionable claim. The statute deliberately brings lottery within the GST framework. That is the starting point. Once that threshold is crossed, we can move to the next questions. Who is liable, where is the place of supply, and whether the tax is CGST plus SGST or IGST. Now come to the first GST question. For the specified supply of lottery by the state government, union territory, or local authority to a lottery distributor or selling agent, the GST framework places the tax liability on the recipient under reverse charge mechanism, or RCM. So in the qualifying transaction, the distributor or selling agent is the person who pays the GST, but do not stop here. RCM tells us who pays. It does not by itself tell us whether the tax is CGST and SGST or IGST. This is the key to the entire issue. The correct sequence is not lottery, therefore RCM, therefore CGST. Or IGST, the correct sequence is: first identify the supply, then determine the place of supply under the IGST Act, then decide whether the supply is intrastate or interstate, and only then apply the appropriate reverse charge mechanism. In simple terms, place of supply first, GST tax type second, RCM third. Now take the first factual situation. State government A supplies lottery tickets to a distributor, and the movement of the tickets terminates within State A for delivery to the recipient. Section 10(1)(a) of the IGST Act provides the general rule for supplies involving movement of goods. The place of supply is where the movement terminates for delivery to the recipient. If that place is State A and the supplier is also in State A, the supply is intrastate. The resulting tax is CGST plus State GST, payable by the distributor under reverse charge, assuming the RCM conditions are satisfied. Now change only one fact. The organizing state remains State A, but the lottery tickets are dispatched to the distributor in State B, and the movement terminates in State B. Under the movement of goods rule, the place of supply points to State B. The supplier is in State A while the place of supply is State B. Therefore, the transaction is interstate. The applicable tax is IGST, and where the lottery RCM entry applies, the distributor pays that IGST under reverse charge. Now we reach the most interesting situation. State government A supplies the lottery tickets to distributor B. But distributor B instructs the state government to deliver the tickets directly to third party C. The invoice may show distributor B as the bill to party, while the physical delivery goes to C. This immediately raises Section 10(1)(b) of IGST Act, but there is an important warning: every third-party delivery is not automatically a Section 10(1)(b) transaction. We must establish who the relevant third person is, whose direction caused the delivery, and what the underlying contractual arrangement actually says. There is another possibility. What if the supply does not involve movement of the lottery tickets at all? Section 10(1)(c) provides a separate rule for goods supplied without movement. The place of supply is then determined by the location of the goods at the time of delivery to the recipient. So again, the physical facts matter. In a lottery GST dispute, we cannot determine the tax merely from the names appearing on the invoice. Now connect the two legal systems. The Lotteries Regulation Act regulates the organizing state, the lottery, and the distributor or selling agent framework. GST law then determines the tax consequences of the particular supply. The Lotteries Act does not itself impose GST. And GST law does not replace the regulatory requirements of the Lotteries Act. The two statutes perform different functions, but the statutory-lottery relationship can become critical when applying the GST and RCM notification. Let us now put the entire analysis into one matrix. State government A to distributor A with delivery in A, potentially intrastate, CGST plus SGST under RCM. State government A to distributor B with movement terminating in B, interstate, IGST under RCM. Delivery to another state can also produce an interstate result depending on the applicable place of supply rule. And where a third person receives the goods on the direction contemplated by Section 10(1)(b, that provision must be specifically examined. Finally, where there is no movement, Section 10(1)(c becomes relevant. If this becomes a GST dispute, what evidence should you examine? Start with the lottery organizing state documents and distributor appointment agreement. Then examine the GST registration inv, delivery address transport documents, e-way bill where applicable, stock records, delivery challan, and any bill to or ship to instruction. Most importantly, establish where the movement actually terminated and why the goods were delivered to that particular person. In place of supply litigation, labels are not enough. The underlying facts and documents matter. So what is the real lesson? Do not reduce lottery GST to the statement, lottery is under reverse charge. That is only the beginning. First, identify the statutory lottery supply, then establish the distributor or selling agent relationship. Then determine the place of supply under Section 10 of IGST Act. Then decide whether the transaction is intrastate or interstate. Only after that do we reach the RCM consequence, CGST plus SGST or IGST. In short, RCM tells us who pays. Section 10 tells us where the supply is, and the place of supply can determine which form of GST becomes payable. Thank you for watching. Remember, in GST, it is not merely about who sold the goods. The real question is, where did the supply take place? For more GST and customs insights, stay connected with Customs GST Advisory. Subscribe the channel and like and share it. Press bell icon for latest notification.